It is our Vedic understanding that wherever there is a temple or a deity, and people who have faith in that deity have not only the right but a duty to offer prayers to that deity. But today, the land that gave this Mimamsa is today governed by a constitutional and democratic polity. And there are different opinions into that. Does this constitutional polity bars or gives freedom to follow this Mimamsa? To dig deeper into this fact, today we have the famous lawyer Mr. Vishnu Shankar Jain, who has been fighting the case for Ram Mandir, succeeded, and now he is fighting the legal battle for what we hear as Kashi Vishwanath, Gyanvapi, Krishna Janambhoomi, and many more temples. We welcome you, Vishnu. Thank you for being with us. So we're coming straight. So you're a very famous lawyer. You're the young face of the, we call resurgence Hindu consciousness, somebody calling it as Hindu fundamentalism. But you're fighting for very specific cause of revivalism, reclaiming of Hindu temples and ancient ones that also have a monumental as well as a civilizational value for the Indian spirit. How did you pick up the cause, or the cause picked you up?
See, the basic idea of all these litigations is to get back the glory which we lost during the slave era or during the Mughal era or during the entire period from 1712 till the constitution was enacted. Though the constitution was enacted in 1950, but the real freedom I feel is not there with the people of this country, because the voice of Hinduism, the voice of civilizational battles were not heard by various systems in this country, and it was treated as a voice which is against the secular ethos of the country. So, when I researched into, I am coming and answering your question, when we researched into various aspects of Gyanvapi, when we researched into various historical as well as shastric importance of Gyanvapi, and the core and the answer of your question lies in this core concept of the importance of Gyanvapi to Hindus.
Right.
And the importance of Krishna Janambhoomi to Hindus. And as per Shastric version, what is the Shastric version of Gyanvapi and Krishna Janambhoomi? So, when we researched into various Shastra and Vedas, so I have came across a very famous book of James Prinsep, Banaras Illustrated, he has written. In that book, he has written that Vedas and Shastras all testify that Visheshwas is the first of the Devas,
Yes.
Kashi the first of the city, Ganga the first of the river, and charity the first of the virtue.
Right.
So, a foreign writer is telling us the importance of Gyanvapi. Our own Shastras are telling us the importance of Gyanvapi. It is a land of salvation. To be precise and to be concise, it is a land of salvation. Whoever worships that place of 5 course of Avimukta Kshetra is blessed with salvation, which is the end goal of any human living being. So, Gyanvapi is very sacred and important to us. Apart from that, same importance is of Krishna Janambhoomi. So, that is why when we understood the importance, the precious, so precious and so important Shastric Mahatva is there of these two places, we chose that we should get it restored, and plus coupled with the fact that the structure itself is proving and showing that there was an invasion in the structure, it was partially demolished and it was used as a mosque. So, as per Islamic tenets also, it is not a valid mosque, as per Hindu Shastric law also, it is not a valid mosque. So, because of these research, we filed the court, we filed the cases in the court, and definitely the entire Andolan and revolution and the movement of Ram Mandir case has also played a very important role.
Because you were representing the Sant Samaj.
No, I was representing the Hindu Mahasabha.
Right.
I was the advocate on record for Hindu Mahasabha from 2016 onwards, before the Honorable Supreme Court, when the matter travelled to the Honorable Supreme Court. And when I started my career as a lawyer, I was fortunate enough to participate in the final hearing of Ram Mandir case, and ultimately the judgment of Allahabad High Court came on 30th of September 2010. So, the entire research which happened and which went in the law books in Ram Mandir case were a very important aspect for us to take up these causes. And apart from that, we strongly believe and feel that injustice has happened with the majority community, and it is a very ironical situation where you would have because you are a very learned person. If you would have travelled across the world, the minority community asks for equal rights. Say that let us please give us the equal rights. It's reverse in India. Here the majority community is asking for equality of rights, and they are saying that please allow us to go to courts. And the minority community, Mr. Ovesi and various famous barristers and everyone is saying no, no, you are not allowed to file a case in the court of law because Places of Worship Act bars you. So, it is a very ironical situation, where a majority community is asking a very basic civil right to have a judicial review, to file a case in the court of law, to prove their point by way of evidence, by way of trial, and that basic right is being denied by the minority community on the garb of secularism.
Okay, how constitutional is when we call, so this it is taking me a little different. You graduated me to 3 of my questions that I'll ask in the following probably series. But now the question is, you said in the garb of secularism. If I come to this particular word of secularism, so the India was divided on the basis of religion, that one country had to be a Muslim country, it is still an Islamic republic, we had to be a Hindu country. And here now we end up being secular, where you said even the majority is pleading, it's seeking, it's actually begging. Maybe not, last 10 years a lot has changed, but what do you say that is secularism way for India? Was it bought in constitutionally? And is secularism delivering to India what equal rights and equality it should be delivering from a legal perspective?
As a lawyer and as an advocate on record practicing in the Supreme Court of India, it completely shocks my mind by seeing this piece of legislation and by reading this word secularism. I don't know so far as the legal aspects which I have read, every word which is brought in law book is defined. Secularism is the only word which is inserted in the preamble of the constitution without any definition.
There's no,
it has never been defined by the parliamentarians. So, whatever is secularism,
how do we interpret? How do we interpret it then?
It is very subjective. We don't know what's the meaning of secularism. Is it are the people to be there are various aspects and layers to this word secularism. Let me decode it. One aspect is that are the people forced to be secular, or what do you mean by secular? Does secular mean that every religion is equal and I am supposed to say that I am equal with Muslims and Christians and various other religions, or I am able to believe that my religion is supreme? Because if you are giving me right to religion under Article 25, I have a right to believe that my religion is supreme. The Muslims have the right to believe that their religion is supreme. The Christians have the right to believe that their religion is supreme. So, who is secular? Are the people secular or the government is secular? Ultimately, the concept was that the state or the government in administration of its powers will not discriminate between the citizens, and that is already imbibed under Article 14. So, there was no need to insert this word secular in the preamble of the constitution and without any definition. So, that is one ambiguity so far as secularism word is concerned. The second ambiguity is that if you will read the preamble, at the end of the preamble there is a date mentioned, that this is the only preamble with a date. I am telling it with a lot of sense of research, because I have challenged this word secularism and socialism in the Supreme Court of India, and the Supreme Court is set to hear this matter in the coming weeks. There is a particular date which is mentioned in the preamble, and the date is we the people of India on this 26th day of November 1949 do hereby adopt, enact and give to ourselves this constitution. So, it was an oath which was taken by the people of India on 26th of November 1949. Have you ever heard of something bizarre like this, that once a oath is taken, after 20-30 years down the lane you saw that, oh, when we took that oath we missed few words, so let us add that in that,
without even defining that.
Without even defining it. So, it was an oath which was taken on that date. By retrospective effect, you couldn't have amended the preamble. That is second point. And third point is that the people are not secular, the government is. And what is secular? Please tell us, please explain us, because for one government to stop puja in Gyanvapi was the peak of secularism, was the very nice example of secularism. For one government to give Hajj subsidy in violation of Article 27 was secularism. For one government to appease minority and bring minority budgets and various facilities for minority is secularism. So, what is secularism? We don't know.
But coming by your word, when you said governments can be secular, which at all was, had to take care of the subjects of the state without considering what faith and backgrounds they come from. So we didn't need this word secular. But
Yes.
can, even in that sense, though undefined, can a secular government impose secularism on its subject?
Secularism, the words which I have used is this, that the government in its administration will not discriminate between the citizens on the basis of their religion. This is the concept which is imbibed under Article 14 of the Constitution.
Right.
So, when this concept is already imbibed, what was the intention to insert the word secularism in the preamble? That is point number one. The second point is very, very important and which goes to the core of the issue is this, that how this word secularism has been used by the government time and again, and what is the motive and object behind using this word,
What
and
does
what is the definition of this word. Because if you will have a little more deep research, secularism was the word which was used by the church, because at that point of time there was interference by the church in the administration. So they said that there will be no interference of the church in the administration. But so far as Sanatan concept is concerned, we believe that dharma is supreme.
right?
The logo of Supreme Court is Yatho Dharmas Tatho Jaya. So we mean we are the country which has to be governed by dharma, and dharma is defined separately in the Oxford Dictionary. So secularism, religion does not is not a synonym or is not a parallel word to dharma. Dharma is a separate word, religion is a separate word. So what do you mean by this word secularism? Are you saying that all the religions are equal? I'm not able to figure it out, because it's so much of ambiguity is there and so much of dichotomy is there, because this word has not been defined by the parliamentarians, and every ruling party uses this word in their own manner to appease a particular community and make their vote bank. This has happened in 70 years thanks to this particular government, that they are functioning in accordance with the constitution.
Great. So, even if I'll take it to a little more diversion. So I understand, as the dictionary goes, if the Oxford Dictionary might have as well defined the word dharma, but it has also defined that secular means which is related to the physical world and physical matter and the matters of the material world, and not something related to theology or higher spiritual or religious matter. That's what secular essentially dictionary wise means. But coming back to the democratic and constitutional polity, does the constitutional and democratic polity of India stops Hindu from asking or from working or demanding that their institutions of faith, their centers of faith, which were the ancient temples, is it somewhere stopping from reclaiming and reviving them?
See, you have asked a very valid question, and before answering this question, let me delve a little bit more into this aspect of secularism. One more dichotomy and irony I want to demonstrate before you today. The Honorable Supreme Court, in the judgment of S.R. Bomai, said that secularism is the basic structure of the constitution, and the governments were dismissed after 6 December 1990, 6 December 1992, on the basis of premise, on the footing that the governments have violated the principles of secularism. We don't know what is secularism. So now coming back to your question, that there is a narrative which was driven in this country from past 70 years, that these kind of litigations, if you want to reclaim back your temples, it's a very communal litigation, it's a fringe litigation, and it is against the secular ethos. That's why when we started this conversation, I brought this word secularism, because I feel that the basic problem is in the mindset, and there is a particular sect of society which believes and feels that if this kind of litigation is perpetrated, or if this kind of litigation is generating in the country, it will sow the seeds of hatred, while the matter is completely reverse, it's completely opposite. It's a research based litigation. It's a litigation which is asking a question, that can you wash your feet and hands on a shivling? And if we are asking this question, is it against the principles of secularism? It is asking a very basic question, that is Krishna Janmabhoomi 13.37 acres of land is the land of deity? We have the proof of title of Lord Shri Krishna. Please allow us to do the trial in the court. How can it be violative of secularism? So the problem is that when we take these kind of litigations, and that's why I am saying that Ram Mandir case is a turning point in the Indian legal history and the Indian history, because for past 70 years, and let me tell you that Ram Mandir case was filed in 1950 by Gopal Singh Visharat. In 1950, the suit was transferred to Allahabad High Court in 1989 after 39 years, when the people had andolans and they protested of pendency of the matter before the
And the
honorable court.
opposite party had not even had any representation till then in the case, I remember.
The Sunni Central Waqf Board had filed their civil suit in 1961 before the Faizabad court.
So how long after the
It was pending in the Faizabad court till 1989.
Right.
So, considering the national importance of this litigation and seeing that sentiments of both the communities are involved after so much of protest in exercise of powers under section 24
So
of
the
the
first
CPC.
response plea was filed in 69, while the first litigation was filed in 50. So that
The
was
first plea of on behalf of Hindu side was filed by Gopal Singh Visharat in 1950.
50.
The UP Sunni Central Waqf Board filed their case in 1961. So then there were other 3 more suits which were filed, and ultimately the cluster of 5 suits became the matter of consideration and adjudication before the Allahabad High Court. The Allahabad High Court transferred the matter to itself in 1989. The matter kept pending before the Allahabad High Court till 30th of September 2010. And then ultimately it kept pending before the Supreme Court for 9 years. So 69 years this entire civilization waited for justice, so that we can see this day of 22nd of January 2024. For this day, generations, 20 generations have waited, and we are very fortunate to see that day of 22nd of January. So what I am trying to say is this, that Ram Mandir case is a turning point, because after Ram Mandir, the Hindu Shastrik Niyam, which we used to argue, which was never heard by a particular section of the society, these kind of litigations were treated as a fringe litigation, a communal litigation, a litigation which is sowing seeds of hatred in the country. I think now the perception is changing, and if a person is asking genuine question on the basis of strong legal research, on the basis of strong Shastric research, I think he has a right to be heard, and you cannot shut his mouth on the ground that it is violative of secularism. It is the most bizarre theory which was ever propagated in this country.
So, it's very insulting and outrageous that one way we are saying that it's secular that somebody goes and washes their feet and hands on a shivling, and even demanding that, you're demanding that this should be stopped and at least an investigation or inquiry should be given. That's called as being opposing the secular spirit of the country. And while somebody, the other party doing it, it contributes to secularism. Is that the way we interpret it?
So it's very shocking. I'll tell you certain very interesting facts. And I am living this case. I'm not just fighting this case. I'm living this case. So each and every date is there in my memory chain as a living entity. So on 16th of May 2022, we found Shivlingam in Gyanvapi complex in the Vazu tank area. 16th May 2022. On 16th May 2022 at 11:30, Civil Judge Senior Division Ravi Kumar Divakar sealed that area. Generally the law is that against the order of Civil Judge Senior Division, you have to go to the district judge, then to the High Court, then to the Supreme Court. But law is different for some particular sections of the society. Against the order of Civil Judge Senior Division, directly the matter was filed in the Supreme Court, and they challenged this sealing order before the Honorable Supreme Court in a pending SLP. And the number of the SLP is SLP Civil number 9388 of 2022. In that SLP, the Honorable Supreme Court kept the sealing order intact, and for the first time in the Indian judicial history, subsumed the order of a civil court to its order. So ultimately what I am trying to say to you is this, that this Shivlingam which was found in this Gyanvapi, we are saying it's a Shivlingam. They came up on affidavit before the court saying that it's a fountain. So we said that all right, the matter has to be tried because we have to proceed with the trial. This has to be decided that whether it's a Shivlingam or a fountain. So I filed an application before the Honorable District Court of Varanasi saying that this should be investigated by an expert body like an ASI. The Honorable District Judge Varanasi dismissed my application on 14th of October 2022, saying that if this exercise will be conducted, Shivling will be damaged. I filed a revision petition before the Allahabad High Court. The Allahabad High Court, after hearing both the sides, on 12th of May 2023, Justice Arvind Kumar Mishra passed a detailed order on an affidavit of the ASI of 54 pages that in this exercise Shivlingam will not be damaged, and this Shivlingam or this structure looks very old at a prima facie in cursory glance. he directed an ASI survey. Now the party who is saying and propagating and believing so much in their cause that it's a fountain, they filed an SLP before the Supreme Court. The Honorable Supreme Court stayed this ASI exercise on 19th of May 2023. So now the fact of the matter is that if you are so strong with your research and if you believe that it is not a Shivlingam, it's a fountain, you should have participated in that ASI survey. You should have said that no, we will not bring an ASI survey, we want an expert from Arab country.
Yeah.
Bring any expert from all across the globe and let it be seen that how this fountain is working. But they are running from the investigation. And when you are asking for investigation, then I am coming back to your question. When any party is asking for investigation, they will say it's a fringe element. It's violative of secularism. It's violative of Places of Worship Act. Without even understanding and reading the legal nuances of Places of Worship Act, they will say it is against the principles of Places of Worship Act. और हमने एक मस्जिद खो दी है और दूसरी मस्जिद नहीं खोएंगे, हमारे साथ बहुत जुल्म हो रहा है, हमारे साथ बहुत अत्याचार हो रहा है. So this is the fallacy, this is the problem, this is the irony.
That brings me to another two questions. I remember when the ASI's investigation, it was said the court had ordered, the Allahabad High Court, that the ASI team should conduct this their whole exercise there. And I remember that when they were going for the ASI survey, I remember it was very difficult for you and the whole team to be reaching there. You were not you had no security perhaps, and there was a lot of restriction from the community that you thought you were limited people and you were sort of mobbed around. Was that a fact?
Yeah, actually what happened, it was not ASI survey, it was a survey of Advocate Commissioner.
Yeah.
What actually happened is that Justice Ravi Kumar Devakar, Civil Judge Senior Division of Varanasi, on our application said that there should be an Advocate Commissioner who should conduct a survey in this complex, Gyanvapi complex, on 2 days, 6th and 7th of May 2022.
Okay.
2 days were given, and from 10 to 5 this survey has to be conducted and submit a report to the Honorable Court. So me and my father and the legal team reached Varanasi on 5th of May. We had a meeting in the hotel room and we decided that how we have to proceed with the survey and whatever our strategies were decided. So on 6th of May, when I still remember very clearly, when we started from a hotel to gate number 4, where we were asked to all gather and proceed and enter the survey area, from Maidagin Chauraha to gate number 4, the entire that entire stretch of around 2 kilometers, if I can guess, was full with members of Muslim community. I don't know, I can't guess the numbers, but I feel that there will be approximately 50,000 people on road that time. And we were we were in our car, taxi car, and we were going to the gate number 4 for conducting the survey. And the situation was so, I can say, intense, and it was so threatening that the entire intention was that this survey team should not enter Gyanvapi complex, and by hook or crook they should be stopped. So it was my father's, I think, willpower. He told me that, Vishnu, because I told him that this is a very dangerous situation, I think they will kill us here because we have no one. And everyone recognizes us. So we are going in the car and they are seeing us in advocate's dress. So it's a very awkward situation. So my father told me that if we stop here and we will be killed, then also we will reach Mahadev. And if we reach gate number 4, rest assured we will again find Mahadev. These were his words.
That's his faith.
This was his word. And we reached gate number 4, and ultimately that happened. On 16th of May 2022, we found Shivlingam in the Wazu tank area, which is yet to be investigated, but we, on the prima facie view, we feel that it's a Shivlingam. And that entire area, let me also tell you, that entire Gyanvapi complex is full with a lot of proofs. We had asked for a ASI survey. The Honorable District Court of Varanasi on 21st of July directed for an excavation in the premises in question. They came against that excavation order to the High Court and the Supreme Court. Ultimately, excavation did not happen. So without excavation, this report has come. But still there are a lot of things which are lying there in the premises in question, and if ASI was given a complete free hand, ASI had given an affidavit that we will not damage the structure will remain intact. That was the order passed by the District Court on 21st of July. But by using modern techniques and non-invasive work, non-invasive method, this survey was conducted. So, I feel that whatever we believe and whatever our Shastras say is there on the spot in Gyanvapi, and it is not mosque, it is not a mosque in the eyes of law.
So I would say it's a, you know, I've been across with these debates, we've shared panels, and I remember that most of the time whenever these proofs that have emerged during of the survey and ASI's affidavit, so the other party, they always keep defying those facts. They keep giving the bizarre arguments that no, it has been by, bought in by Deen Ilahi Akbar, he built it, so he has Hindu symbols over there. And sometimes they say that the whole exercise that you are conducting over there, the whole litigation process that you are doing, it is against the Places of Worship Act. This has been quoted, I think, in a series time and again. Every time a Hindu party goes and asks to reclaim its temple, even through legal methods, it is said to be a violation of the Places of Worship Act. What are your views on that?
So, you have asked me two questions. The first question is so far as the theory of Akbar is concerned, and the other question is applicability of Places of Worship Act in this premises in question. Now, let us have the Places of Worship Act which is enacted by the Parliament. I am not asking or I am not requesting you to read the Places of Worship Act which is a narrative Places of Worship. There are two Places of Worship Act which are there, which are prevailing in this country. One is the Places of Worship Act which is by a very famous barrister, which is a narrative, which is not enacted by Parliament, but it is his own act. And the other Places of Worship Act is the verbatim Places of Worship Act enacted by the Parliament. So, I think as lawyers we have to follow the Places of Worship Act which is enacted by the Parliament. That Places of Worship Act uses the word religious character in section 3 and section 4 and says that 15th August 1947 the religious character of any premise in question will remain the same. Now, coming to this question, what is the definition of religious character? Suppose I enter into a temple and I offer namaz there. Will the religious character of temple change?
Brilliant.
There can be only one answer, that religious character of temple cannot change. Once a property belong and vests to the deity, till the end of the time it remains deity's property. So, if you come and enter and offer namaz there, the character of temple will not change.
Right.
Vice versa, if I go and offer puja in a mosque, the religious character of mosque change, there can be only one answer, that religious character of mosque cannot change. So, I want to request the famous barristers and everyone that please read the word which is used in the act, not a narrative driven promises which were given to you in the Parliament, in the floor of the house. What the parliamentarians have enacted in the act and has used in the act is religious character has to be determined. And it is not that I am just arguing or making submissions in front of you and this has not found favor with the court. Let me tell you that the Honorable District Court of Varanasi has given a judgment, whatever I am saying, on 12th of September 2022. The Allahabad High Court has given a judgment on 31st of May 2023 by Honorable Mr. Justice J.J. Munir. The Honorable Mr. Justice Rohit Ranjan Agarwal has given a judgment on 19th of December 2023, and he has held that religious character have to be determined by way of a trial. Because once, how will you determine religious character? If I am saying it is a temple and you are saying it is a mosque, there has to be an ASI, there has to be an advocate commission, there has to be videography, there has to be photography, the historical records by virtue of section 57 of the Indian Evidence Act will be read, and after seeing the composite evidence, after weighing the composite evidence, the Honorable Court will pass an order that on 15th August 1947, the religious character of this premise was of a temple or of a mosque. So why Anjuman Intizamiya and the Muslim side is shying away from this exercise? Because the fact of the matter is that it is the ruins of a Hindu temple.
Yes, in character, it is a Hindu temple.
It is a Hindu temple. You just convert it and put 3 domes over it. The religious character of a temple will not change.
So they say that just because we have changed the character of your temple, it should be maintained.
It should be maintained. So we have, it's like a Gundaism कि हम आपके घर में घुस आए, हमने आपके घर के 10 कमरे कब्जा कर लिए हैं और ये उनका इंटरप्रिटेशन है प्लेस ऑफ वर्शिप एक्ट का. अब इस 10 कमरे को रेस्टोर करने के लिए बात मत करिए, नहीं तो इस एक्ट का उल्लंघन हो जाएगा. ये बहुत ही एक इन अ वेरी, इफ आई कैन एक्सप्लेन इट इन अ वेरी सिंपल लैंग्वेज, दिस इज द कॉन्सेप्ट.
Right. So, but actually the whole act does not bar in investigating and determining the character of the.
That's the point. That's the point which the Allahabad High Court has held on 19th of December 2023, and I don't want to quote the observations of the Honorable Supreme Court, because these are legal discussions, but the matter had travelled to the Honorable Supreme Court, and the Honorable Supreme Court had said, observed during a legal discussion, that Places of Worship Act, it was a prima facie view that Places of Worship Act does not bar determination of religious character. So, according to me, Places of Worship Act is a bad law. It's a dream situation for all the citizens of this country that this act should be repealed by the parliament, but be that as it may, when it is done by the government, it is done. Through the legal interpretations, this litigation and this civilizational battle is continuing.
Since you've said that, this question is like you have read the mind and spoken for millions and millions of Hindus here. So they feel that this particular act was bought in deliberately to somewhere stop Hindus from reclaiming their temples, which were like demolished and razed over by the invaders. What do you think would have been the premise of this particular act?
See, to actually read the parliamentarians and the discussions which have happened in the parliament at that point of time, the discussions which have happened are different, and the act which has been enacted is different. So, actually there is one section of the society and one segment of the society which is going by the discussions which have happened in the parliament. Because actually when Ram Mandir Andolan was at its peak, Narasimha Rao government enacted the Places of Worship Act with the intention that after Ram Mandir other disputes should not be raised. But what is written in the act is determination of religious character on 15th August 1947. So, I think.
So was it the intention, just because we have given you you have Ram Mandir, you cannot have other temples?
See, as a lawyer, I do not believe in narratives.
Right.
As a lawyer, I believe in the legal document and the act which is enacted by the parliament, that has to be implemented. That has to be interpreted by the courts of law. Whatever you are thinking as a parliamentarian is immaterial so far as legal aspect of that act is concerned. So that's what I am saying. I am answering your question. And just see the flip side of this. Suppose let us for a moment agree with the interpretation given by the other side, that Places of Worship Act after Ram Mandir case, the other litigations, that is the interpretation which they are giving, that after Ram Mandir case the other litigations for other temples cannot be revived or cannot be filed in the court of law, and this country is governed by secularism, and therefore after Ram Mandir no such litigation can be filed in the court. Now, can you just analyze this argument? If you believe and feel that secularism is the basic structure of the constitution, then Baba Saheb Ambedkar was asked the question that in this entire constitution what do you believe is the most important article. So, Baba Saheb Ambedkar replied that article 32, which is the right of the people to approach the court, is the most important article of this constitution. It is the heart of this constitution. So, ultimately what I am trying to say is the right of the citizens of this country to approach the court of law is the basic structure of the constitution, and 5 judges bench judgment is there of the Supreme Court which has held this. So, if you are saying secularism is the basic structure, the right of the citizens of this country to approach the court is also basic structure. So, ultimately the interpretation which they are giving, which will lead to a conclusion that people will not be able to approach the court. You can't find a litigation. So, you shut your mouth,
no matter how you
keep
feel.
your research with yourself and you don't talk about it. That is the basic argument.
So, the basic argument which you have brought into light is that, so okay, we are bringing in this act, you have the Ram temple, but though it may be the violation of the constitutional values, but through this Places of Worship Act, we are somewhere limiting especially the Hindu community from going to the court in the matters of faith in reclaiming their temples.
Yes. See, we have challenged the constitutional validity before the Honorable Supreme Court, the constitutional validity of Places of Worship Act. The Supreme Court has issued notice to the central government. The central government is still yet to file its reply to that petition. So, the Places of Worship Act has various fallacies. This was one of the fallacies which I highlighted on your show. The other fallacy is that the cut-off date which is used in the Places of Worship Act. Why 15th August 1947? On 15th August 1947, we attained independence.
Right.
So, after independence we woke up, and after 70 years we have woken up. Now, we are deciding what to do.
Right.
So, why 15th August 1947? If there has to be a cut-off date, it should be 1192, when the last Hindu ruler Prithviraj Chauhan was brutally massacred by an invader. So, what should be the cut-off date is also another discussion which has to happen in Places of Worship Act. Then why you are leaving just Ram temple? Why? Just because the people of this country gathered on the street and they had revolution and they had Andolan, you exempted Ram temple. Why not Krishna Janmabhoomi? Why not Kashi? Why not Bhoshala? Why not Tilewali Masjid? Why not Qutub Minar? Why not Taj Mahal? Why not many more temples which are demolished and which are converted into a mosque? So this is it not discriminatory? Is it not arbitrary? Are you discriminating between Ram, Shiv and Krishna?
So you do feel.
So there are lot of dichotomies and anomalies so far as Places of Worship Act is concerned, and I strongly believe, and it's my legal opinion, that, and I'm saying it on your show, that believe me, that one day Places of Worship Act will be repealed either by the court of law or by the government. It will be repealed. It will be declared as unconstitutional. It's my legal opinion. It will be declared unconstitutional. It's a black law. It will be declared as unconstitutional by the court, or it will be repealed by the government.
Well, coming that to be, because you're very passionate about what you're doing, and we do feel that, the according, so you've been talking about that, where you've done your research legally in the Shastric manner. Do you feel that, the Hindu spirit that we are talking about, the Hindu revival, some people are also calling it a Hindu fundamentalism. So is it people try, undermine the efforts of, warriors such as you who are fighting the Hindu battle, that, these people are fundamentalist. It's very, it's the Hindu fundamentalism on the rise, and because it's a reactive fundamentalism. Do you feel that, it has been suppressed for a very long time, still the efforts are being put to suppress it? And do you feel there is a role of the legal system also there for being, for almost 60 years after independence, we are still fighting to say that, claiming your own faith, asking for your own identity is not fundamentalism?
No, I am saying I am proud to be called as a Hindu fundamentalist.
Great.
What is wrong in this word fundamental? Fundamental is that you are not compromising with your fundamentals.
Right.
You are not compromising with your basics. So how this, actually the problem is this narrative. They have made this Hindu fundamental word such a bad word, they have portrayed you in such a bad light that people feel shy in saying that I am a Hindu fundamental. If I believe that my religion is supreme, if I believe that my Shiv, my Krishna, my Lord Ram is supreme and the path which they have shown is the important path, so I am a Hindu fundamentalist, I am a Jain fundamentalist. What is wrong about it? Why should we shy away from this word? And why should this word be seen as a curse? My father, I remember his words still reverberate in my mind. He says that, Vishnu, I am a Hindu fundamentalist. I boldly admit that I am a communal Hindu. What is wrong in this? A Muslim can be a communal Muslim. And he can still be secular.
Yes.
So I can't be a Hindu fundamentalist, still be secular.
Very nice. So it brings to me the very question, and I think a lot of people would want an answer to this. So you are they say that, Hindus and Jains are a different, it's another divide that has been created. You are a face, Vishnu Shankar Jain, and you're fighting for the Hindu cause. How do you see this whole divide between the Buddhists and Hindus and Jains? Why do you see, and what do you feel is the legal premise and the legal argument to demolish it?
See, if you will read the history of Jainism, if you will read the Ramokand mantra and the various mantras and the sermons which are given to us by our gurus, the concept of Jainism is we always greet each other by saying Jai Jinendra, that you have to take control of all your indris. So Jainism and Hinduism is not different in terms of theory. The way of worship can be little different, but which is very, very prevalent in all the parts of the country. If you will visit Kashmir, the Kashmiri Pandits will have a separate way of worship. The southern priest will have a different way of worship. If you will visit the Jain temple of Ranakpur, their Bhairav Bhairavi is there. Their puja happens. In Ranakpur Jain temple, I am telling you. And always you will find Hindu and Jain temples together. You will always find Hindu and Jain temples together. In Qutub Minar, the Quwwatul Islam mosque which was built, it is mentioned there that this temple was 27 Jain and Hindu temples were demolished, and this Quwwatul Islam mosque was built. So always Jain and Hindu temples have been they have been together. The theory and the concept is together. See, only aspect is, so far as Bali Pratha is concerned, so far as Hinsak practices are concerned, in that Jainism does not believe. But apart from that, more or less the entire concept and the theme is the same,
so that's
to attain salvation without harming anyone. So if someone is trying to bring a divide between Jains and Hindus, they should read the history of Jainism. And let me tell you, please visit Girnarji Parvat. If you visit, it's a very sacred Parvat for all the Jains and for Hindus as well. In Girnar Parvat, there is a place where there is an idol which is made by Lord Krishna himself, of Neminath Bhagwan. Neminath Bhagwan is the cousin brother of Lord Krishna. Many people do not know this fact. So history of Jainism is a very checkered history, it's a very long history, and it's always been an eternal and integral part of Hinduism, or Hinduism has been an eternal part of Jainism. Both have always gone hand in hand. So all these are efforts to say that for vote bank politics, to make Jain as minorities, to say that you are different from Hindus, these kind of divides may be created. So we do not believe in this kind of divides, and we believe that we all are together and we all are having the same theory.
But I think that's the beauty, that the whole Sanatan philosophy, the Sanatan Sabhyata, it has been giving the freedom of evolving in even in the dimension of faith, that while we come from the same roots, we may have a different philosophical branch to grow and evolve in. So that's how I think we are Hindu, Jain and Buddhists are even connecting, because there are the same roots. But I would come to one more question, because that's what is the argument going around the kind of fight that you have taken up. So a lot of people say that there are two ideas of, there is an idea of Bharat and there is an idea of India. So the people who believe in the idea of India, they say like, we should not look back. So we have gained independence, now we are democratic country, we have a constitution, the country runs by the constitution. Why do you want to fall back? What is our Sanatan Sabhyata? What was our civilization? So let's just grow, let's just develop, talk of education, talk of this, talk of that, and don't talk of the whole where your roots are. And the whole spirit of the idea of Bharat is that we are conscious, we are proud of our roots, that we have a civilizational history, we take pride in that, we take inspiration from that, and with that inspiration we grow and we develop into the future with a futuristic vision, and India is progressing. So you are a young face, you are a people, sort of an inspiration for youth today, who is educated, who is learned, who is grounded in his own faith and constitution and civilizational values, and still very progressive. What are your views on this idea of Bharat and idea of India?
I'll just give a small example to explain this answer, to explain this question. If you go to a village, आप अगर किसी गांव वाले से मिलेंगे, उसे कहेंगे भैया आपके जो परदादा थे वो क्या करते थे, तो ही विल टेल हमारे परदादा यहाँ पे ऐसे. अच्छा, आपके उनके दादा क्या करते थे, वो बताएगा कि हमारे दादाजी ऐसे थे, वो ज़मींदार थे, वो ये करते थे, वो ऐसे ऐसे करते, सारी बातें बताएगा. नाउ यू आर टेलिंग दिस मैन टू आइडिया ऑफ इंडिया दैट आप अपना हिस्ट्री भूल जाओ. द सेम थिंग एक्चुअली यू आर टेलिंग दिस सिविलाइजेशन दैट यू हैव सच अ ग्लोरियस हिस्ट्री, you forget that history. And I am telling you that this is, and I am very strongly saying, this is a conspiracy to degrade us, to demean us, and to take away from our roots, so that our adhyatmic shakti which we have is in our roots.
Yes.
The adhyatmic shakti which all the Sanatanis have is in Gyanvapi, it's in Ram temple, it's in Krishna Janmabhoomi, it's in many more temples. This is not just a land for us, piece of land for us. This is a Jita Jagta living entity for us. We worship our country as Bharat Mata. So you are saying you forget the theory of Bharat Mata. You forget this theory and you believe, you just get into some country which is leading to nowhere. So no one can forget his roots. I remember a very important poem. It says like this: breathes there the man with soul so dead, who has never himself has said, this is my own, my native land. So
Wonderful.
So you want to say to us that we should forget our own country, our own civilization, our own history, and we should believe in this idea of India. So according to me, the Article 1 of the Constitution of India says, India, that is Bharat, shall be the union of states. So idea of India, if ever there is such idea of India, is I think gone, and we all believe in the concept of Bharat and Bharat Bhumi, and we will definitely check our past, we will go into our glorious past, we will get lessons from our glorious past, and definitely this will be a country which will have a past, present and the future, because we have a very long checkered history when we were Vishwa Guru. So if we have to again become Vishwa Guru, we have to see that where our power and our ethos lies.
So that brings me to my conclusive questions. So a lot of people say, like, earlier you said, like, now you're very proud, people are coming out and they're wearing their Hindu and their Sanatan identity on their sleeves with pride. It's it is there's a perception that it's easy now to approach the courts. Recent times have changed. Hindu consciousness is you've just the giant has woken up. What according to you has changed in the recent times? Is it the change in the leadership? Do you feel that there's a more pro environment for to voicing the Hindu concerns or voicing the nationalistic concerns, which were earlier said to be making people apologetic of their identity?
See, I strongly believe, and I have no hesitation in saying this, and this is my position, that after 2014, the real independence we have got.
After Mr.
Yeah, after Prime Minister Modi have sworn in as the Prime Minister of this country, we have got real independence from that day. And Article 19, which was a dead letter in this constitution, we exercised right to speech and expression after Prime Minister Modi has taken over as the Prime Minister of this country. Because before that, I can give you many more examples when there was a Prime Minister of this country who had banned so many books which were written by the members of the Hindu community. So many books are there which were banned. Freedom of speech and expression were not there if you want to propagate your idea. Freedom of speech and expression were only for those people who believe in the idea of secularism. And idea of secularism is a mixed theory which I have already demonstrated before you in the earlier version. That what is the concept of secularism and who is secular. If you are favoring a particular minority and if you are talking about minority appeasement, it is the best example of secularism. So I think that after this present government has taken over, the real freedom we have got and the freedom of speech and expression we have got, and I believe that you are absolutely right, and I feel as a youngster that things have changed after 2014. Now people are not fearing speaking the truth, they are developing. I still remember, and let me tell you very frankly and very candidly, before 2014 you will see various channels not talking about these issues. These issues were not taken up in the mainstream media, or apart from that mainstream media, as mainstream political issues also.
Right.
They were issues which were not concerning this country. So now these were the voices of the people which were curbed by might of power. So I believe the Prime Minister and this present government has actually given true freedom to the masses, saying that all right, you speak whatever you want to speak within the framework of law.
But a lot of people call him that he's a dictator, he controls, he doesn't let people work, or like, why would these, even the young people now, I've seen a lot of people who are, some random YouTubers coming up and saying, so he's a dictator. Do you think that so you've given him a very different picture?
Yeah. So who had imposed emergency in this country? Who had brought Places of Worship Act? Who had brought WAF Act 1995? Who had enacted the Minority Commission Act 1992? What were these pieces of legislation? You have to judge a government by the legislations which they brought.
Right.
You have to judge a government by the legislations which they brought in the parliament.
The way they've
so I'm just giving you so I'm just giving you an example of these 4 or 5 pieces of legislation which were brought by the government. And you see the pieces of legislation which have been brought by the present government. Article 370 has been repealed, Citizenship Amendment Act has been brought, and many more such things on legal aspects have been brought so far as codification of CPC, CRPC and various other aspects are concerned. So I think this government, you are calling him as a dictator, but can you tell us that one example where he has abused his power, or where he has gone beyond the constitutional limits, or where he has acted beyond the constitution? We have, I can give you n number of examples where the governments in the past, apart from forget about the legislation, they have abused their powers. They have abused their powers, and let me give you certain examples. If you will remember, in Gyanvapi case only, in December 1993, a particular government, Samajwadi Party government, without even passing a written order, through the Vyas Parivar from this cellar. They dispossessed them from this cellar which is on the southern side of Gyanvapi mosque without any written order. They did iron fencing in the Gyanvapi premises without any written order. They abused their powers, which has been held by the Allahabad High Court by yesterday's judgment
yes.
by Honorable Mr. Justice Rohit Ranjan Agrawal. Now let's move further. There was a government, Samajwadi Party government in Uttar Pradesh. The Akhilesh Yadav government, and I am telling you on record because I have fought that case, so I am telling you the legal history. They released a hardcore terrorist who are now convicted by the courts of law, saying that they are innocent Muslim youth. It was their election manifesto. When they came to power, they passed an order under section 321 of the CRPC for releasing those hardcore terrorists who are accused of blast in Sankat Mochan in Lucknow civil court in various parts of Uttar Pradesh. We filed a petition before the Allahabad High Court. A 3-judge bench was constituted and they declared such act as unconstitutional. The matter travelled to the Supreme Court and they spent so much of money from state exchequer to defend that, to get that order set aside. Ultimately, they did not succeed, and many of them got convicted by the Honorable Court. So this is there was a minister, Mr. Azam Khan, who refused to take oath of the Constitution. Do you know? It's a legal history. He only took oath of secrecy. He did not take oath of the Constitution. The Mulayam Singh Yadav was sitting on the stage and he prompted him that please take the other oath. He said, no, I will not take the other oath. We filed a petition in the Allahabad High Court. Then the Allahabad High Court said that you can't function as a minister, and then he had to again take oath. Muhammad Ali Johar University was created by him. So these are blatant examples of abuse of power.
Particular situation, since you've mentioned, I am bringing
I'm sorry to interrupt. The Endowments Act, various temples which we are facing problem, that our temples are acquired by the government who has sowed the seeds of temple acquisition. It is the Congress government who has sown the seeds of temple acquisition in violation of Article 25 and 26. I am answering all the things within the purview and the question which you have asked me.
Right.
That kindly see these examples. The seeds of temple acquisition were sown by a particular government, and today we are facing that problem. The batch of matters are pending in the Supreme Court. In Karnataka, 3,500 temples are acquired. In other states, Madras and everywhere, so many temples are acquired and they are passing laws and laws to get and grab the money of the temple. I am fighting case of liberation of the temple of Hanuman temple in Kishkinda, where the priest, he has gone on record to say that the temple money is siphoned off by the government. He is the head priest, he developed that area, the Koppal district in Karnataka, Anjanadri Parvat, and when that Parvat and that temple got pramanit by his sadhana, the government took over that temple, H.D. Kumar Swami's government, and they are taking money of the temple. All the donations they are taking, there is no hisab, there is no bahi khata. They just file an affidavit. You are not there in the premises.
Right.
You are not there in the temple. So the government says that आज इतना रुपए आया और हमने इतना रुपए रख दिया. तो इसका कौन है इसका गवाह? Who is there? So this is, I am just giving you an example. This is happening on a large scale in this entire country. And who has sown the seeds? Is any mosque or church acquired by any government? Only temples are acquired by the government. I am saying that if there is mismanagement in the temple, there are various other means to deal with it. You can constitute a Hindu board. Then you cannot
single out only temples.
But you can't single out temples and just keep acquiring it. And the matter is pending adjudication in the Supreme Court. It is not being heard. So the issue is this. And Shabrimala, the judgment has come. So the point is this, that these are blatant examples of abuse of power by a particular government. Waqf Act. After defence and railway, Waqf is the third highest landowner of the land in the country. Third highest landowner in the country after defence and railway. And it is not my statistics. The Andhra Pradesh High Court has given the statistics in 2008.
And how
I think if you will review it today, the Waqf will be the largest landowner of the land in the country.
I would like to know how was Waqf board empowered so much, and by whom? See,
if you will read the history of Waqf Act, the initial Waqf Act was in 1936. After that, Waqf Act initial Waqf Act was of 1923. Then UP Waqf Act 1936 was enacted. Then Waqf Act 1954 was enacted. In that, limited powers were there. But Rajiv Gandhi government in 1995, the Narasimha Rao government and Rajiv Gandhi government, after amending Waqf Act 1954, gave arbitrary powers to the Waqf board, and certain sections I am just demonstrating before you. This is the most draconian piece of legislation and abuse of power against the majority community. Under section 4, 5 and 6 of the Waqf Act 1995, initially the word which was used was person interested. So if you acquire my property, or if you declare my property as a Waqf property, suppose here this studio we are sitting, and by forbidden it does not happen, but if Waqf declares this studio as a Waqf property under section 4, 5 and 6, that notification was not applicable on you, because it is a dispute between Shia and Sunni Waqf which had to be adjudicated by the Waqf tribunal. So you are not supposed to go to the Waqf tribunal, because the word which was used under section 4, 5 and 6 was person interested. In 2013, the Congress government amended section 6 of Waqf Act 1995, very minute work ma'am they have done, and they brought this word person aggrieved. So it means now, and it has been interpreted by the Supreme Court, that all the sections of the society, if your property is declared as the Waqf property and it comes within the notification under section 4, 5 and 6, you have to challenge that notification in the Waqf tribunal. And the irony is, how will you challenge the notification? When you will come to know about the notification, there is no provision to give you notice. There is no provision to give you notice.
So they could simply declare and
so
take
they can keep simply declare, and if you don't challenge it in the tribunal within 1 year, that order has become final. So that's how they have become the largest.
They can declare, they cannot send the notification. After 1 year, they can take away
No
property.
provision is there to send you the notification, just like land acquisition under section 4 and 6 of the earlier land acquisition act. There was a preliminary notification and a final notification. So anyone's land who is getting acquired, they had a right to file objection, then they had the right to know that okay, your land is getting acquired and you can file objections, and then the final notification used to come. But here the draconian law is that there is no provision for any notification or any notice.
I won't even know my land is taken.
You won't know. So when you will know, 40, 50, 60 years would have passed by.
And then you just have to give it up.
And then you have to just give it up, saying that this thing we were shouting from so long. In Tamil Nadu recently you have heard the incident where entire village is declared as a Waqf property. Taj Mahal is declared as a Waqf property. In Surat, a municipal corporation is declared as a Waqf property. In Allahabad, where Shaheed Chandrasekhar Azad had given his shahadat, that park is declared as a Waqf property. So this is the I can say power is given. There is a very important legal proverb: power corrupts, and absolute power corrupts absolutely. So you have given the power,
and you given
so they are misusing their power. Then section 40 of the Waqf Act. Suppose this survey which I am telling you under section 4, 5 and 6 happens once in 10 years. But if they forget to get anything done in these 10 years, section 40 is another power, section 41 and 43, where they can declare any property as Waqf property. And if it belongs to society or trust, you don't have to give a notice to society or trust whose property you are acquiring. You have to give notice to the registrar of the society or trust. And you know, and we all know what happens in the registrar's office. So many communications so many communications are just thrown away. They will not tell you that Jaya ji, आपका जो property है वो वफ़ ने वफ़ घोषित कर दिया, आप इसलिए अपना notice रख लीजिए. Will they do that? It's just lying there. It's just lying in their office. So ultimately, what will happen? If your property is notified under section 40, your land is gone. Then section 53 and 54. For you or for me, the law is that if someone usurps your land, you have to file a civil suit for eviction, just like I am doing in Gyanvapi in Mathura, and fight a long battle, just like in Ram Mandir 69 years long battle. But if you acquire a Waqf land, usurp a Waqf land, or illegal encroach of Waqf land, they can direct the state government to remove that encroachment. The DM and SSP is bound to comply with their orders under section 53 and 54. Under section 83 of the Waqf Act, Waqf tribunal is there, where one member has to be a Muslim member. Under section 85, the civil court's powers are barred. Under section 89, the Waqf board is given a parallel government status. Just like section 80 of the CPC, if you have to file a suit against the government, you have to give them 2 months prior notice. Under section 89 of the Waqf Act, same provision is there. So if you have to file a case against Waqf, you have to tell them that, sir, we are going to file a case against you. So what will happen? What will be the impact? Those cases will never be filed, because their gunda elements will reach the person who has given this notice. Then under section 101, all the mutwallis of Waqf are declared as public servant. Can you tell me one single piece of legislation in this country where any Shankarachar, Mahan, Purohit, Pujari has been given as a public servant status? No piece of legislation I have found.
And they are entitled to all the benefits of that?
If you touch them, it's an offence under section 21 of the IPC. They are public servants. And under section 107 of the Waqf Act, they are exempted from limitation. So even after you are telling me कि ज्ञान व्यापी में इतने दिन के बाद क्यों आ गए, कृष्ण जन्मभूमि में इतने दिन के बाद क्यों आ गए, for them the limitation act does not apply. They can come at any point of time. इसीलिए ताजमहल को वक्फ संपत्ति घोषित कर दिया 2005 में, जिसके खिलाफ एएसआई ने सुप्रीम कोर्ट में अपील की हुई है. Yes, it's a hard fact.
So according to what
it's a total discrimination on the face of it. It's abuse of power on the face of it by a particular government to appease minority community. What more example do you need?
So you made a very clear distinction even from the, we can judge a government by the legislation that it passes, that who is who is ruling a dictatorship
and let me just end this Waqf Act with section 108. Under section 108, let me tell you, when the country was divided on communal lines, the members of Hindu community who travelled to this country, they believed that they will get the property of the Muslim brothers, because Muslims had left the property to Pakistan and they had acquired the property of Hindu brothers. So the Hindu brothers who have travelled from Pakistan to Punjab, Haryana and various parts of the country, if they are residing in any property who belongs to Muslim members,
they were entitled
to get ultimately the ownership rights of that property. Right. There was an Administration of Evacuee Property Act 1950. Under the Administration of Evacuee Property Act, by virtue of section 11, that property was, custodian was the central government. That as of now, central government is the custodian, and we will see in future what we have to do. In 1984, the Waqf Act of 1954 was amended. Section 66H, H for Himachal Pradesh, was enacted in the Waqf Act 1954, and those entire properties were given to the Waqf Board by Rajiv Gandhi government, and that same provision you will find under section 108 of the Waqf Act. So this, the custodian was the central government. Central government had to give it to the Hindu brothers, rather they gave it to the Waqf Board. And the Waqf Board today in Punjab, Haryana and various parts of the country are taking rent from us. Earlier the rent was 100 rupees, 200 rupees. So people never used to mind for 70 years. Now the rent has increased to 30,000, 40,000, 50,000, 1 lakh rupees. So now the people are having the pain. So the person who had to become the owner is a tenant in his own land, and that entire money is used for funding litigations against us. In Kashi Vishwanath, UP Sunni Central Waqf Board is contesting, in Gyanvapi, in Krishna Janmabhoomi, in Ram Mandir. All these litigations are conducted by the Waqf Board. And who is funding the Waqf Board? From where the Waqf Board is getting money? From us. So this is, I am again saying that if someone will read the history and the legal history and the parliamentary enactments and the blatant abuse of power by the past governments, it will shock the conscience of any youth, and it has shocked my conscience, and therefore I am before you.
So it's a very clear distinction who is a dictator and who is not, and who's use and abuse their power, and who have actually served the country. Thank you, Vishnu, for spending your time with us, for sharing your insight and so much knowledge with us. We were very delighted to have you here. Thank you so much, and with this we conclude.